Hey everybody, Brett Thompson here, Thompson Law Group. We're doing another installment of the Teaching Tuesday in the Closing Ninja classroom. And as normal, we're going over Virginia law as it pertains to real estate contracts and real estate law. Had a question come in regards to adverse possession. What is adverse possession? So normally, title to real estate transfers either by a deed or by a will. But there are other ways to transfer real estate through the courts, and there's a doctrine under Virginia law entitled adverse possession. So what is adverse possession? Basically, if you possess a piece of property, or it could be a part of your neighbor's property for a period of over at least 15 years, you could petition the court and ask the court to declare that you own it via adverse possession. Now, there are certain elements involved with adverse possession that must be met. So what are those elements? We've got actual, continuous, exclusive, hostile, open and notorious, and under a claim of right. And I'm just going to go down each one and explain each element of adverse possession. Number one is actual. So you have to do some action to declare your claim to the property. So if you had a neighbor, you could fence off a portion of your neighbor's property, enclose it, maybe landscape it, maybe put a driveway there, maybe build a shed there. So you're doing something that will openly show that you are claiming title to that property. Continuous, so it has to be that claim has to be continuous over at least 15 years. So if you were to abandon the property and your claim for any time, that would stop the clock. Okay. There is something called tacking. So, for example, if your dad used a property and claimed it by adverse possession, and then he died and you inherited it, you could add on your time to your dad to equal the 15 years, which is required under the law. The next thing is exclusive. So you have to be the exclusive possessor and claim of the property, meaning that it can't be like woods where you hunt on the property, but other people hunt on the property as well. So you have to exclusively be claiming the property as your own. Nobody else can claim the ownership interest. Hostile. So it's got to be hostile, meaning it's got to be adverse to the actual title owner of the property. So, for example, if your neighbor is allowing you, is giving you permission to put landscaping down or enclose a part of his area, that does not suffice. It's got to be adverse. So you got to make a claim that, hey, I own it, and it's got to be adverse to, for example, your neighbor's claim of title to the property. Next is open and notorious. So it's got to be obvious, basically. So you got to tell the whole world that, hey, this is my property, despite what my neighbor says. And your actions have to be at least constructive notice, if you will, to your neighbor. So your neighbor would be on notice that you are making this claim, which is adverse to his claim. Finally, under a claim of right. So you have to show that it's your intention to use the property. You're claiming it. You're claiming that you have a right to use it as well, which is adverse to the actual title owner of the property. So there are some elements, and if any one of those elements that I went over, if you can't prove that in a court of law, then you do not rise to the level of adverse possession. So you have to meet all the elements, which are actual, continuous, exclusive, hostile, open and notorious, and under a claim of right. And that all has to be done and continued for at least 15 years. And then you could petition the court and say, Your Honor, I have earned this property via adverse possession. I hope that helps. Have a great Tuesday, guys.